Ipob fought incessantly over court's new decision against Nnamdi Kanu ahead of his final verdict. You see what this final verdict is giving birth to. The federal government are just trying to influence the courts ahead of the final verdict. And this is the reason why I will advise the courts to work with what they have gathered so far. There should be no amendments, and nothing should tamper whatever has been taken note of. And they must know that it is not only the Nigerian government that is observing this very trial. The whole world is observing Nnamdi Kanu's trial. Maybe that is what they don't know. I will remind them. You understand? Nnamdi Kanu's trial is a worldwide observed trial. So nobody, no Jupiter will trick anyone. The world are watching and taking note of everything. So no matter how they try to maneuver it, I don't think that is going to work. It's not going to work. So it is left for Justice Nyako. If she wants to maintain her name, let her maintain it. She must not abuse any opportunity given to her. You understand? And that's just it. Let's quickly go through the content and know what is actually talking about. The indigenous people of Biafra has accused the federal government of deliberate attempt to introduce empty charges in order to continuously keep Nnamdi Kanu in detention. The group also said the federal government had constantly been amending its charges so as to prolong the issue of Kanu unconditional release from the Department of State Services Custody, DSS. In a statement by its media and publicity secretary, Emma Powerful, on Wednesday, Ipob said the federal government had carried out 6 successive amendments to the charges filed against Kanu in its desperation to manufacture offenses that might provide suitable grounds to prefer charges where no offense known to the law existed. It pointed out that the manner in which Kanu was brought into the country was a grievous infraction on international convention, treaties, and protocol to which Nigeria is a signatory. The statement read in part: as such, there is no court in Nigeria that has the competence to ever conduct hearing on any of the frivolous charges filed against Kanu without first undoing the illegality that brought him to Nigeria in the first place by taking him back to the country where he was brought from. Even the Attorney General of the Federation, in an erudite extract he endorsed in his foreword on a United Nations study on extradition concerning Nigeria, totally agreed that extraordinary rendition is in itself a crime against humanity. Ipob said that if the federal government and the AGF knew what they were doing, they would save themselves from the disgrace that was about to befall them, because Kanu committed no offense known to the laws of Nigeria and the world for that matter. The statement added, "If we may ask, what happened to the charge of treasonable felony earlier preferred against him? It has now been amended to the present new 15 counts, which still do not hold water. Rendition, according to the information approved by the AGF, is a general term for all procedures, including extradition for returning wanted persons or aliens generally from one jurisdiction to another, unlawful or irregular forms of returning persons wanted for trial or punishment, including abduction, kidnapping, and the notorious extraordinary rendition." Extraordinary rendition is a government-sponsored arrest, kidnap, and abduction of persons wanted, accused, or convicted of a criminal offense, either against the state which sponsored the arrest, kidnap, or abduction, or to a willing third party. The Umaru Dikko affairs of 1984 is an example of an attempt at unlawful rendition. After a coup d'etat in 1983, the federal military government of Nigeria requested the British government to surrender Umaru Dikko, a former minister alleged to have been involved in corrupt practices. Before the British government responded to the request, an intelligence officer from the Nigerian security forces with 3 Israeli nationals abducted Dikko and attempted to cargo him to Nigeria in a crate. This attempt was foiled by the British security apparatus. The abductors were jailed and the relationship between Nigeria and Britain became strained. Although not successful, it was an attempt by Nigeria to go against the international norms in expressing its political will. Everybody knows Nnamdi Kanu is innocent of the so-called treasonable felony allegation and extraordinary rendition, or whatever they call it, and they too know, and that is why you see that they are now pushing for termination. They don't want the trial to continue. They are now working to discontinue it. It cannot work. It can never work. Why? Because the trial has gone far. That's one. Then 2, Nnamdi Kanu has almost won the case. So that very idea of let's call it off and all of that should be a thing of the past. Nobody is going to accept that. They are not. It's not Nnamdi Kanu's trial. It's not an ordinary trial. Okay. All right, my dear listeners, as you've heard. Okay, let's hear you and know what your opinion and your idea on this very broadcast may be. Don't forget to leave them below the comment box. Click on the subscription buttons as well as bell buttons to get updated each time we upload any new videos. Thank you.